Hello, I'm Rashi Goel and I am pursuing BLLB from University of Petroleum in Energy Studies, Dehradun. And currently I am a legal intern at LEXIS and Company. So in today's video, I'll be talking about copyright issues which are faced by e-commerce industry. The technology in India has taken a revolutionary turn in forms of internet. It has touched all the spheres of our lives. It also has become the basic element for conducting commercial transactions and empowering and connecting to its consumers and businesses at all levels. E-commerce being unprecedented and using a network that uses non-proprietary protocol, safeguarding its creative content and the information made available to the public at large. It becomes the top priority of the business owner, as not only there is a risk of theft and duplication, but importantly it also signifies a protection against unfair competition. So copyright not only protects databases but also to the software, website design and creative content such as text, images, audios, videos and graphics. Having a copyright protection in e-commerce industry, it stipulates monetary penalties against the infringer who is using work without any permission. Now let's move to the basic issues faced by the e-commerce industry. So the first issue is e-contracts. A valid contract shall consist of offer and acceptance, consideration and a capacity to enter into a contract. The terms and conditions associated with an e-commerce platform shall meet with all the requisites of a valid contract and in compliance and in insurance of e-commerce transaction. However, e-contracts are basically in the form of a click wrap, browse wrap and a shrink wrap contracts. These three are basically the types of e-contracts. So in a click wrap contract, the contracting parties usually affirms its acceptance by clicking on the I accept tab with the scroll button box that allows the contracting party to view the terms and conditions of the contract. Next is browse wrap contracts. Usually using such browsers or mere use of sites enables the terms binding on the contracting parties. And last is shrink wrap contract. The terms and conditions can only be read by contracting parties only after the opening the box within which the product or a commonly license is packed. These types of contracts are mostly used and relevant in e-commerce industry. Also, the Indian Contract Act 1872 provides no requirement that the contract shall be physically signed and allow for certain contracts to be made in the other form than in writing. However, the main issue here arises in the nature of e-commerce industry is that it is difficult to factually check the age of the person transacting the online, which then become a problem for an e-commerce platform, as entering into a contract with the minor is void in nature and this creates a further liability. Second issue faced is Indian law fixation. In the United States of America, as compared to India, original work of authorship must be fixed in a tangible medium of expression for a copyright protection. For example, spoken words or live broadcast will be entitled to copyright protection only if they are reduced in some tangible form. However, the position of the same under the Indian Contract Act 1957 is opposite. The requirement of fixation in India under the Indian copyright law is silent apart from some mention of sound recordings, dramatic works and a cinematographic film. In the region of online communications, many works are stored on video RAM of the display monitor, which is temporary and unclear whether this would amount to the sufficient storage or fixation under the Indian copyright laws, and it is for the entitlement of the copyright protection. Third issue is lack of safe harbor provisions. E-commerce falls within the ambit of intermediary with respect to Section 2, Clause W of Information Technology Act 2000 and the Amendment Act 2009, not specifically stating the word e-commerce but including the words or provides any service with respect to that record, thereby enlarging the scope of terms of the intermediary to be read with exceptions which is given under Section 79 of the IT Act. The intermediaries must carry due diligence procedure in order to avail exceptions as per the Information Technology Intermediaries Guidelines Rules 2011. However, they shall be liable for third parties' action in the case where intermediary has knowledge or has been notified by the government or its agencies that the data, communication links, etc. are being used for some unlawful activities and not acted upon it. Even with respect to Copyright Act 1957, e-commerce company have not received any sign of relief under the amended provisions of Section 52, Clause 1, Subclause 2 and Section 52, Clause 1, Subclause C, stating that transient or incidental storage of work made in the technical process of electronic transmission or communication to the public shall not constitute any infringement of copyright. And Section 52, Clause 1, Subclause C further provides that the transient and incidental storage for the purpose of providing electronic links, access or integration where such links, access or integration has not been expressly prohibited by the right holder, unless the person responsible is aware or has reasonable ground for believing that such storage is of an infringing copy and shall not constitute an infringement of copyright. So these sections seems to be acting as a safe harbor provisions but lack of precision with respect to the intermediary's liability and online market become the safe harbor in further dependent on the intermediaries having reasonable ground for believing that such storage is not of an infringing copy, since the word transient or incidental storage of work remains unexplained. So the fourth issue is publication. The copyright date begins from the date of publication. Hence, once the information is put up on the site on certain date, it would amount to publication and copyright protection would begin on such date. But important consideration is the place of publication. If the work is published in India and some other country simultaneously, and if such other country has a period of protection which is shorter or less than the protection which is given under the Indian copyright law, then such work may deem to be published under that country, and such work may lose copyright protection under the Indian law if that country fails to grant protection to the Indian copyright, thereby India not recognizing it. Now, the fifth and the last issue is data scrapping. It is commonly known as web scrapping. This method is used to pull an important data or information from a website to an output format which is readable by using a computer program or software. Within the fraction of seconds, data or information is pulled out irrespective of any size or number of pages, thereby causing the ambiguity in declaring the copyright owner as copyright vest in the literary work which is given under Section 13, Clause 1, Subclause A, which is read with Section 2, Subclause O of the Copyright Act 1957. Providing that complications falls under the ambit of literary work, thereby indirectly including data scrapping, which is nothing but the compilation of the information. It is not clear that a content importer becomes a copyright holder, as this also leads to the infringement of the copyright table or copyrighted content on the website if done without any permission. Thank you everyone for watching my video. I hope you like it, and if you did, Please give it a thumbs up and share it with your friends and family. And don't forget to let me know your feedback in the comment section. Stay home, stay safe, stay healthy.